Welcome to the shit show. A three-ring circus in the canvas of your mind, with all the bells, whistles, and imaginations of your delusion of this circus called life, where you were the ringmaster. Then you handed the keys to some silly-ass clown.
Step right up to the twisted parade where the calliope hums and the shadows won't fade. Brass horns blare, but the tune's off key. A carnival king grins, bow down to me. Bass drum pounds like a runaway heart. Snare snaps, crack, the crowd comes apart. Laughter coils like a snake in the grass. You're part of the act now, so don't slip through the cracks. Oh, the carnival king rules with a crack crown. Organ riffs spin as the tent spins around. Whistle, shriek, run, but your feet stay glued. He'll feed you to clowns if you dare to boo. Mirrors warp what you thought you knew. His voice drips honey, but the truth's askew. I'm the ringmaster, jester, and beast. A circus of chaos where the nightmares feast. Lions yawn, but their teeth gleam bright. Fire eaters spit embers to light up the night. The midway's a maze with no exit in sight. The smirk says you'll love every second of pride. Oh, the carnival king rules with a cracked crown. Organ riffs spin as the tent spins round. Whistle, shriek, run, let your feet stay glued. He'll feed you to clown if you dare to boo. The calliope wheezes a funeral march. Balloons pop like thunder in the pitch dark. He'll juggle your fate with a wink and a sneer. The show never ends. Why'd you think you're here?
Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, of course, hit that like, share, and subscribe, as it said. And appreciate Jack and his crew for coming over. May not be the normal stream that people are used to. I'm going to be reading some of the documentation I drew up. I've got a forcible entry and detainer coming up on Monday due to some chaotic environmental nuisance and nothing being done about it. And of course, that allows things to escalate. And they try to turn around and they're trying to evict us for clear and present danger because of the escalation. So first, what I'm going to do is I've got the research material on specific cases, and I'm going to read off that. And I will drop the link if anybody wants to come up. So just let me know. But I'd like to get through the paperwork first. So please pay attention. I think it's important for anybody that goes through this. And of course, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know, because every situation is different. And so I'm going to start off with the leading case that we're referencing here for the forcible entry and detainer. is Hillview Associates versus Bloomquist from 1989. And it says this is the most significant Iowa case regarding retaliatory eviction. The scenario is a group of tenants formed an association to complain about maintenance and management issues. And that's what we're talking about with your forcible entry and detainer evictions. It's always under a maintenance schedule, and that's in your statutory code for the landlord's statutory duty for maintenance issues. And when we talk about tenants breaking their lease, that is a maintenance issue. And so after a heated meeting with the management of this association, the landlord turned around and served them with notices of termination. And that's a retaliatory event. It says the result, the Iowa Supreme Court held that the tenants had a valid defense of retaliation. The key legal rule, the court established that once a tenant proves they made a good faith complaint about maintenance or health and safety issues within 6 months of the eviction filing, there's a presumption of retaliation. Now in Iowa, they've changed that from 6 months to a year. It says the burden then shifts to the landlord to prove non-retaliatory reason for the eviction. And what we're looking at here is my companion has a disability. It's a frontal temporal dementia. And so when there's excessive noise and everything coming from the upstairs apartment, namely children running, stomping, screaming, hollering, jumping, and all that, all day long from 8 a.m. till 9, 10 p.m., sometimes even later. We've heard them at 1:30 in the morning. We're talking about a 2-bedroom apartment with 3 adults and 3 children. And that's might seem excessive, but we've had the same condition where we had 3 adults and 3 young children living in the apartment upstairs before and never had this issue. And the lease term we're talking about is the noise ordinance, which talks about incidental noise. Now, incidental is here and there, not constantly all day long, every day. So we called in and complained about that. And rather than the landlord doing the statutory requirement under that maintenance to give the neighbors upstairs a 7-day notice to cure, or they would face eviction, the landlord failed to do that. So it allowed the neighbors upstairs, despite my complaint to them several times, to escalate. Now I no longer complain. I pound back, and it disrupts the other neighbors. So the other neighbors are calling and complaining about our situation. So the outcome for the tenant, for several of the tenants, the eviction was blocked because the landlord could not overcome the presumption that they were being evicted for complaining. So that's telling us there's a presumption in law that there's a retaliation if I make a complaint and then we're evicted shortly thereafter within the year. The next case, Staley versus Barclow, 2008 or 2013. Although this case dealt largely with illegal lease provisions, it reinforced the tenant's right to sue and defend based on the landlord's failure to maintain the premises. The scenario there was the tenants challenged various lease terms and the landlord's failure to perform repairs. The result was the Iowa Court of Appeals affirmed that landlords have a non-waivable duty to maintain fit and habitable premises under Iowa Code 562A.15. And this is similar to the, like I said, the noise ordinance. If somebody was sitting there and lighting off fireworks all day long, every day, that would be a noise ordinance violation because it's not incidental. Okay, it's not one firecracker here or there. So the result is that they have that non-waivable duty to maintain fit and habitable premises. And again, this is in reference to my companion who gets very upset when she can't have her peace and quiet. her frontal temporal dementia is an emotional imbalance. And so I've learned to deal with that. But on my own, that's an incidental thing, because for her, her emotional imbalance is only incidental to certain situations. But when you have a situation that is consistent and constant, that emotional imbalance is now consistent and constant. And that causes not an incidental reaction between her and I. The impact on the forcible entry and detainer is this case often cited in forcible entry and detainer defenses show that a landlord's attempt to evict a tenant who is demanding these statutory rights is retaliatory in nature, not by statutory code. This goes to that good faith and fair dealings part. The third one is B.I.G.S.C.U.N.T.S versus D.U.M.B Real Estate 2022. This case provides a more recent look at how these defenses are handled. The scenario, the tenant, B.I.G.S.C.U.N.T.S, complained about various maintenance issues, non-working washing machines, ACs issues, and neighbors' disturbances. The landlord eventually declined to renew the lease. The outcome, while the court in this specific case eventually found for the landlord, because the tenant had already vacated and the retaliation wasn't proven to be the primary motive for a non-removal or non-renewal, the court reaffirmed that retaliation is a valid defense in possession action if the tenant can show the victim was triggered by maintenance complaints. Important exceptions. Under Iowa Code 5628.363, a landlord can still win the forcible entry and detainer even if they were negligent, if the tenant is behind on rent. We've always been on time, never failed to pay rent on time, have never had an eviction on our record. And the next one is the tenant is behind on rent for like if you withhold, excuse me, not next one, but the next part of that is that if you withhold rent because the landlord is failing to maintain repairs and stuff, the procedure for that under 5628.27, you may lose your retaliation defense. So you have to stand firm and stand your ground in good faith. Pay your rent, stay there, force them to go through the forcible entry and detainer. Do not accept a 3-day notice to quit. That's not a valid court action. That's just a notice by the landlord that they want to evict you. You have to force them. Okay? The landlord needs the tenant to move out to perform actual repairs is the other exception. There are no repairs that need to be made. The remedy in this case for the maintenance issue is not a repair issue. It's an incidental noise issue that is not incidental. The Supreme Court case that brought about the retaliation foundation of defense for forcible entry detainer resulting in the Uniform Residential Landlord and Tenant Act was Lindsay versus Norman, 1972, and this is a U.S. Supreme Court. This case is the reason why retaliation and maintenance defenses are handled primarily at the level or state level rather than the federal level because of the statutory requirements. They're not federal requirements. The scenario, tenants in Oregon refuse to pay rent because their landlord failed to maintain the building in a habitable condition. Specifically, the city had declared the house uninhabitable. They challenged Oregon's eviction laws, arguing that the law violated their due process and equal protection because it did not allow them to raise bad maintenance as a defense for not paying rent. That's where that came from. But at the state level, non-payment of rent after you have an issue allows the landlord to move forward with his forcible entry and detainer. This is why you have to stand your ground, pay your rent, and that's what provides you protection. The ruling in the U.S. Supreme Court upheld the landlord's right to summary eviction process. The key takeaway is the housing is not a constitutional right. No matter what you think about domestic tranquility and general welfare in the Constitution, it does not guarantee the constitutional right of housing. The court famously stated there is no constitutional guarantee of access to dwellings of a particular quality. This is why you're allowed to stay in tents if you're homeless. State law controls. The court ruled that states are allowed to treat duty to pay rent and duty to maintain the property as separate issues, again, because it's statutorily regulated and not federal code. This means the state can choose to allow an eviction for non-payment, even if the landlord is breaking maintenance laws. Again, reiterating, that's where it was established, is in the Supreme Court. You can go ahead and just move out. But if you do so, you're likely to lose any future cases in suit. Procedural victory. And this is, before I go on any further, this is what we're attacking, is the procedural legal error, not by the court, but by the landlord. The procedure legally was to issue a 7-day notice to cure to the upstairs tenants. They failed to do that. That is the procedural legal error. The court did strike down a requirement that tenants pay a double bond, twice the rent, just to appeal an eviction, ruling that this unfairly discriminated against poor tenants. Why this matters? Because the U.S. Supreme Court declined to create a federal habitability defense. The Iowa Supreme Court and the Iowa legislature became the final word on the matter for Iowans. So again, don't believe me, don't believe the neighbor in a different state. Do your research according to the state you live in. In response, the legal climate created the case like Lindsay in Iowa and other states adopted the Uniform Residential Landlord and Tenant Act. This is where current protections come from, not the federal. Iowa Code 562A.36. This was specifically written to provide protection that the U.S. Supreme Court declined to grant in Lindsay. It ensures that even if housing quality isn't a federal constitutional right, retaliation for reporting maintenance issue is a protected right under Iowa law. Federal circuit influence. While not the U.S. Supreme Court, the D.C. Circuit case, Edwards versus Habib, 1968, is the spiritual ancestor of Iowa's law. It was the first major case to rule that a landlord cannot evict a tenant simply for reporting housing code violations to the government. And that's where we have a sticking point, because there were other maintenance issues that came about before the incidental noise. Iowa, or all states, have a filter regulation that those filters in the furnaces are supposed to be replaced every month. Well, since we got a new management company, we had not gotten a new filter. So we called in and requested for a new filter. And rather than just complying with state statutes and giving the filter once per month, which their records would show by inventory that they didn't disperse such filter, they requested that I send them a photo. Again, sorry, I am not the maintenance tech. I am just the tenant. The maintenance is on the landlord. I am not going to send you a picture. A couple days later, they still hadn't come by with a new filter. So I simply texted and gave her fair warning that if we did not receive a filter for the furnace, we would simply do by law our duty and call the fire department for an inspection for safety and habitability reasons. Bingo. And that day, 11/5 of 2025, we got a filter. We haven't received a filter since. 11/5 was a new filter. December 5th and January 5th, we were supposed to get a new filter. So it's now been 2 more months since we've not gotten a filter. So again, a repeated action, failure to provide the filter is a pattern of practice. Now we live in Iowa, and so we have snow. And again, the maintenance in regards to snow removal is on the landlord. However, they failed to do that. And that is a very important issue, again, as to safety and habitability with my companion and her physical disabilities. 2 knee surgeries and multiple surgeries on her feet. She has to walk with a walker. And having unshoveled snow or unshoveled sidewalks does not allow for her to be able to do that safely. So I myself had to go out and shovel the walks. Okay. Now, I'm not the only one that has these complaints. The neighbor right next door also has a complaint about a neighbor, the upstairs tenant, parking in front of her garage. Also, the neighbor is the one doing the shoveling of the back sidewalk so they can get to their car. The neighbor also has not received a new filter in 3 months. Pattern of practice, 2 witnesses. Now, entrance into the court. It's imperative, again, like I said, to contact the landlord and make a record. The same thing with the courts. When you walk into that court, you have to establish a record. So I've drawn up some questions that I'll be asking the court to make sure that the court is operating in good faith and fair dealings as well. So I've got, first of all, a request for a court reporter per Iowa Code 602.6603. Is there a reporter present, or is this being recorded? It better be yes. If he answers no, it shows absolute contradiction to his duty, which is a fiduciary duty, and bias. Is the device currently active, and may I have the name of the person responsible for the log of this record for an appeal? And this is important because you need to get those transcripts. And I'll also note here that I suggest, if you have the money, to hire your own court reporter. That way those transcripts can't be doctored. Your Honor, for the record, are you presiding over this matter today in your Article 3 judicial capacity under the authority of the Constitution as its constitutional protection under Iowa law, as it relates to my natural person capacity in relation to health and safety, not maintenance, and not the legal person of capacity of record? He better answer yes. Is this court currently proceeding as a court of record according to the common law, i.e. my natural person, or is this an administrative proceeding under statutory rules, i.e. legal person / firm name? Not my name, naturally, but a firm name where it too is doctored. Does the court recognize its obligation to uphold the United States Constitution and the Constitution of the Republic of Iowa as the supreme law of the land in this specific case? And I'll remind you folks, in Iowa and I believe most states, eviction is an equitable action. Will the court be applying the rules of evidence and common law protections of due process throughout these proceedings? Again, he better say yes. Does the plaintiff have a verified claim of specific injury in fact, or is this action based solely on an alleged violation of administrative code? If they don't have a witness specific to the injury, i.e. the tenant upstairs who has issued a complaint after mine stating that I was threatening him, posing clear and present danger, then there's something wrong. If he does not show up in court professing his injury, saying that I threatened and put him in fear, then case is lost. Because the management can't be firsthand witness. They are second person because they're the ones that the first person filed a complaint with. It has to be the tenant upstairs. Does the court intend to prioritize statutory summary procedures over my constitutionally protected rights to property and due process? Again, he better say yes. If the court chooses to deviate from the common law or constitutional protections, will the court provide a written finding of fact and conclusion of law, explaining the jurisdictional basis for doing so. Again, if they do so, they better say yes. If any of these answers is no, or they determine that they are providing a summary judgment on administrative code, then, Your Honor, I respectfully request a clarification. Is it this court's position that the Iowa Administrative Code supersedes my constitutional right to due process? And if he says no, then he contradicts himself in any other no or admittance to administrative procedure. My statement of defense. Your Honor, I am Keith, and this is Joyce. I'm 60, she's 70, and I am a person with disability, currently going through cancer issues, still recovering, and she has frontal temporal dementia, as well as the 2 knee surgeries and multiple foot surgeries that I mentioned. I am here today to contest this eviction because the landlord has failed to meet the legal burden of clear and present danger under Iowa Code 562A.27a, which is the one they're using against us. The lack of evidence for clear and present danger. The landlord alleges that I'm a danger because of a firsthand witness, the tenant upstairs, saying he was threatened and was in fear. However, on December 24th, Christmas Eve, 1:30 p.m., the police department was called for disorderly conduct. The threat, the clear and present danger. Officers Sullivan and Payne of the Waterloo Police Department responded to my home. After investigating the situation, the officers determined that the noise from the upstairs apartment was not incidental, but was a legitimate and continuous disturbance. The stomping, jumping, screaming, hollering, running, and all that. They admitted to it. They chose not to file a police report or charge me with any offense because they recognized I was responding to an escalated situation caused by the neighbors upstairs. I have subpoenaed these officers to testify to these facts. Without a criminal act or a genuine threat, the landlord's claim of clear and present danger is factually unsupported. 3, provocation and landlord's failure to act under Iowa Code 562A.15, the maintenance issue. A landlord has a duty to maintain a fit and safe premises. I notified the landlord via phone and text that the upstairs neighbor was mocking us and stomping, running, jumping, screaming, and howling. And I'll note here that I did address the neighbor first before I addressed the landlord. I first went up and knocked on their door. First time, they answered. The gentleman claims he doesn't understand English. The woman I know understands English. I told them they needed to quiet it down. It was upsetting us downstairs. It was too loud. They said, okay, but it continued. So again, a couple days later, I went up and knocked on the door. This time they refused to answer. And this is where the lady answered through the door, not by answering and opening the door, but through the door, and mocked us, saying, what, don't you have children? It doesn't matter whether I've had children. The issue here is incidental noise. Then, of course, I addressed them several times before I contacted the landlord. Then when the landlord didn't do anything about it, then I escalated. Then I grabbed a board, and every time I heard him stomping, running, jumping, screaming, and hollering, I started slamming it on the door frame, letting them know it was too obnoxious. They still don't want to settle down. So then I took that board and I went up and I knocked on their door with the board. letting them know, because I'm not going to knock that hard on with my knuckles, but I know that knocking on that door with that board is going to be loud. That's all it was. The landlord responded after I texted and called them by calling it incidental noise and refused to intervene, refused to uphold their statutory duty to file or give the neighbor upstairs a 7-day notice to cure. In other words, they had to stop with the excessive noise, or otherwise they would be evicted. By not doing so, and then taking their complaint that I was threatening, it's now on the landlord failure to do what they were required by that administrative statutory law. They're the ones subject to that law, not me. I'm subject to good faith and fair dealings, and I operate in good faith and fair dealings. If one seeks equity, they must do equity. By failing to address the neighbor's chaotic environmental nuisance, the landlord allowed the situation to escalate. My reactions were a direct result of being trapped in a hostile environment that the landlord refused to manage. And it's only me reacting to the neighbors because my companion can't. She reacts to me. I'm the one that has to deal with her and her emotional distress. That's what I was trying to quell. 4, request for reasonable accommodation. When the landlord gave notice of a 3-day eviction under the Americans with Disability Act, they are supposed to accept what's known as a request for reasonable accommodation. In other words, people with disabilities can't just pack up and move in 3 days. They're disabled. So they're requesting a reasonable accommodation, which is an extension of time to allow for that disability. Otherwise, that is discrimination against that disability. That is a suitable offense. That is a constitutional violation. Because I am a person with disability, the law requires the landlord to provide reasonable accommodations rather than eviction if my conduct is related to my disability and can be managed. I have formally requested that the landlord pause this eviction and instead address the noise triggers from the upstairs unit. The landlord has refused this accommodation, which I believe constitutes housing discrimination under the Fair Housing Act. Okay? And again, that's that thing where they deny the statutory responsibility to do so. So a pattern of practice, twice they denied their statutory responsibility to act appropriately through proper notice and proper request for reasonable accommodation. The landlord is attempting to use emergency, clear and present danger eviction to remove an elderly, disabled tenant rather than dealing with a neighbor dispute they ignored. I ask that this case be dismissed for lack of evidence, or at minimum, stayed, paused, to allow for a fair housing investigation as it relates to the ADA. This is an action in equity, and the principle of equity requires that the plaintiff come to court with clean hands. He who seeks equity must come with clean hands. The landlord has failed this standard in an equitable action. We, in good faith and fair dealings, gave proper notice both to the upstairs tenant and the landlord of the disturbance on December 16th and prior. Instead of fulfilling their duty under Iowa Code 5628.15 to provide a safe and quiet environment, the landlord chose to ignore the provocation. The landlord is now using a clear and present danger filing as a shield for their own failure to manage the property. We urge the court to hear the testimony of Officers Sullivan and Payne. They will testify that the disturbance was real, it was caused by the upstairs tenants, and that they, as law enforcement, found no cause to charge the defendant. Not only did they not charge the defendant, but there is not even a police report or service notes, just a call report noting that they came out. So we need to have them on the stand so they can give their determination of why they discerned that there was no clear and present danger. Questions for the officers. Officer, when you arrived, did you speak with the upstairs tenant regarding the noise behavior reported by another resident? They'll say yes. Based on your questioning of the upstairs tenants, did you find Keith's complaints about stomping and disorderly conduct to be credible or supported by your observations of the tenant's demeanor? Again, they'll say yes. So they'll confirm my complaint is valid and that theirs isn't. Did you specifically instruct or warn the upstairs tenants to cease the noise or change their behavior to avoid further escalation? And again, they will say yes. Did you speak to another neighbor named Gabriel who interpreted for the neighbors? This goes to the issue that they didn't understand my communication. And that's bullshit because, again, the neighbor also addressed me when I went up there and knocked on their door several times. He speaks English. He speaks their language. And he told me specifically he would talk to them and tell them they needed to quiet down. So now we have two people, the officers and the neighbor, that told them they needed to quiet down along with me. 3 or more witnesses. What sense of the situation did you gather from Gabriel as to the initial concern and escalation? And did he give you any timeline of events? Now, I don't know if he gave me any timelines, but I guarantee you that Gabriel told him that he had, in fact, talked to the neighbors before about the issue and asked them to quiet down. In your professional judgment, did you see any evidence that Keith posed a clear and present danger to anyone? Or did it appear they were responding to a persistent, unaddressed nuisance? And again, when they walked away and didn't charge me with disorderly conduct and didn't file a police report or service notes, that is clearly evidence on the record, off the record, that they, under their professional legal expertise, saw no such evidence. So the record still bears no evidence of clear and present danger. Is it true that you chose not to file a criminal report or issue a citation against Keith because you surmised the situation was a civil neighbor dispute exacerbated by noise issues? And again, they'll say yes. Did the upstairs tenants mention to you whether the landlord had issued a specific warning to them in a 7-day notice to cure? And again, they'll probably say no, because I don't know that one has ever been filed because if it were given to them, because if it were, they should have quieted down. And if they didn't, then they should be the ones that were evicted. So again, evidence that's not on the record that evidences that the landlord failed their maintenance duty to provide that notice. Your Honor, the officer's testimony shows that even without hearing noise themselves, their investigation led them to believe the upstairs tenants were the source of conflict. They warned them, not me. The officer's discernment proves that a reasonable person could see this was a nuisance, yet the landlord, who was given notice weeks prior. So understand, this isn't just 1 or 2 incidents. This went on for weeks. Refused to issue a 7-day notice to cure to those tenants, choosing instead to ignore the initial cause. The fact that these officers, who are trained to identify danger, walked away without filing a report is the strongest evidence that no clear and present danger ever existed. The landlord is acting blindly to the initial cause. We gave notice on December 16th. The landlord had the power to stop the escalation by issuing the 7-day notice to cure, and instead they issued a general notice that did nothing to protect our right to quiet enjoyment. The general notice was just a text to all tenants reminding them of the lease term about incidental noise. It's not a warning. That's just reiteration of the noise term. They're required again, by statutory law, to give the neighbor a 7-day notice to cure. That's why I have that question in there. And the record will show that they gave none. My agitation was a foreseeable result of the landlord's bad faith performance of her duties. This is the same agitation of Jesus flipping the tables, folks. As this is a case in equity, the landlord cannot ignore root cause and then seek to evict the victim for reacting to it. I remind you, this is an equitable action in these courts. Then I've got some questions for the neighbor, but I'll leave them out to keep her off the record. But I assure you, Your Honor, the neighbor's testimony provides a second witness to a pattern of practice by the new property manager, Listy Wickman. Out of chaos comes order. In other words, the chaos, or rather negligence, of Listy Wickman to her statutory duties under Iowa Code shows a pattern of practice that brings her to full culpability in these matters. We believe rather than deal with us as tenants, she is retaliating to remove us unjustly. This is clear and convincing evidence under Iowa Code. As a part of the remedy, we seek for damages in the amount of $3,000, which we feel is fair and reasonable for the chaos we've been subjected to, as well as having to prepare for these proceedings. And I'm telling you, folks, we have spent hours upon hours upon hours looking for other places to move to. It's a low-income housing situation here, so our rent is kind of low, but everywhere we look, the rent is going to be higher. As well as all the time I spent researching to provide all this stuff so I can present this case in court without an attorney, without representation, without representing the facts, but actually going to the facts that are already on the record and the facts that are missing that should be there. I'm not going to represent anything. It's already there. This includes research and time spent looking for another place to live and document production, all my paperwork, cost, printer ink, papers, all that. And that's costly. I'm much more expensive than an attorney if you want my help. But I do it cheaply for myself, but it's still not real cheap. In short order, limitations of disabilities, both mental and physical, it is extremely hard to find a place for both my companion and I, and the support companion for my wife, Eddie. You know, places that allow dogs, particularly large dogs. Closing statement. Request for equitable relief. Your Honor, we are here today in a court of equity. The law of equity is not a cold mechanism. It is a search for truth and fairness. As the scripture says in Isaiah 1:17, we are called to seek justice, encourage the oppressed, and defend the cause of the fatherless. Today, that cause belongs to an elderly and disabled resident who has lived in good faith while being subjected to a trial of environmental discord. The principle of clean hands. Equity requires that a plaintiff come to these equitable actions with proof that they followed equity. The landlord has failed this standard. On December 16th and 17th, the defendant did exactly what a good tenant should do. They reached out for help. They gave notice to the continuous non-incidental stomping, running, jumping, screaming, hollering, and mockery from the unit above. The landlord chose to be blind to this distress, labeling it a legitimate nuisance as incidental. By ignoring her duty to maintain a fit and safe and healthy premise, the landlord allowed this crisis to grow. To now use a clear and present danger filing to punish a disabled person for reacting to a nuisance the landlord refused to fix is the very definition of unclean hands. We have heard the testimony of Officer Sullivan and Payne and a neighbor. These officers are experts on public safety and they were at the scene. They witnessed the environment. They chose not to file a report or charge the defendant. They recognized that the danger here was not the resident, but the environment. If the police sworn to protect the peace did not find danger, then this court should not find one today. The shield of retaliation under Iowa Code 562.8.36, there is a presumption of retaliation when eviction follows a good faith complaint. And like I said earlier, it used to be 6 months. Now it's a year. So if we complained a year ago and they decided at the beginning of our lease for a year that they didn't want to renew the lease and nixed our lease at the end of the year, that could be considered retaliation. The defendant spoke up for the right to peace in December. The landlord responded with an eviction in January. This is not a pursuit of safety. It is a pursuit of convenience at the expense of a vulnerable life. Conclusion, a request for mercy and justice. Jesus taught that a house divided against itself cannot stand. She's divided in her mind. That's the house, folks. And that we should first remove the log from our own eye before seeking the speck in a neighbor's eye. The landlord has a log of negligence in her eye. We ask this court to act in equity, dismiss this action for clear and present danger, or for lack of evidence of clear and present danger. Order a reasonable accommodation that requires the landlord to address the upstairs nuisance or provide a transfer to a safe, quiet unit or another dwelling. Restore the peace that was lost when the landlord ignored the first cry for help. As Micah 6:8 reminds us, we are required to act justly and love mercy. We ask the court to do both today. Requested remedy. The defendant requests that the court acknowledge the presumption of retaliation based on the December 16th complaint. Hear the testimony of Officers Sullivan and Payne and the neighbor regarding the lack of clear and present danger and pattern of practice of failure of maintenance duties. Dismiss this action as retaliatory and discriminatory filing. Like I said, Americans with disability, they're required to respond appropriately to their requests for reasonable accommodations and extend that civility. An extension in good faith, we would expect a rental credit for the undue stress and anxieties if we are to stay. In other words, it would not be a loss if we stayed another month and were then not required to pay rent, but extend that as part of the remedy for damages as a credit, rather than them paying us. They just accept a credit that we just automatically get another month or two, or whatever the court might decide. As well as to further ensure our health and safety in future incidents. If that were be the case, they need to do something about the upstairs neighbor. Settlement. The eviction is dismissed with prejudice. The landlord provide a reasonable accommodation by transferring the resident at the same rent rate or subsidizing any extra, or allowance to stay with actual damages, if awarded, used as credit. So if we're given $3,000 and are allowed to stay, which we might prefer, even despite the circumstances, which I doubt. I don't like dealing with people that are ignorant and don't deal in good faith. Then that whole $3,000 would just go towards rent. Actual damages to include stress on both tenants and any moving or legal expenses and expenses incurred for filings, recordings, services, notary, etc. And then I've got an affidavit of fact regarding a landlord non-compliance and retaliation that I cannot read. That is specifically for the court. And so basically, we've got solid standing. And I've talked to several people, both on both sides of the fence there, attorneys and landlords, and as well as a homeless coordinator with the local mental health institute in regards to my companion, the homeless caseworker. Every last one of them says I've built up a very strong case and that they honestly believe we will absolutely win. And I don't have much doubt, except for the fact that I know how these courts operate through previous 94 cases. So I'm fully confident, but there's still that tinge of that corruption that is systemic that I've been talking about for a long time, folks. And so you see me wearing the mustache again, because here we are. This was back before the hearing, and we've had the hearing, and we've gone through a lot of different things, and I'll be posting more as I've kept people updated on my El Perro channel. I'm going to now start downloading things here to this channel. And yeah, just like I expected, I know how these courts work. And so they're trying to slip a Louis on me, trying to keep the record silent. And we're not going to allow it. So we're already at the point where we've issued HUD investigation, IOCR, which is Iowa Office of Civil Rights Commission, investigation from them. The Institute for Justice, as far as the judicial complaint. We've also sent the judicial complaint to the Judicial Qualifications Commissions. I do have the bond paperwork from a previous case that I was involved in a couple years back, failure to appear for jury duty. So all I got to do is get the new bond information for this year, and I can get it from that paperwork. Just contact and say, hey, what's the new information? Can you send it? And so they'll all have their bonds. And yeah, we'll see how it goes. Appeal to the Iowa Supreme Court is already in, because consequently they dismissed it without prejudice in favor of the plaintiff, even though the plaintiff was barred from getting a dismissal. They went to court with unclean hands. They admitted right on the stand that they committed statutory violations and failed to give the 7-day notice to cure the upstairs tenant, and therefore we should have automatically got a summary judgment in favor of the defendant and against the plaintiff for what's known as presumption of retaliation for filing a eviction so soon after a complaint. And then on top of that, not only did they file an eviction after the complaint, but they ignored the complaint, which is another strict statutory duty. So we've got them on the Iowa Uniform Residential Landlord and Tenant Act and the Federal Housing Act. So everything's supported by case law as well as the dismissal was dismissed at cost to the defendants, which again is against Iowa state law, State versus Paglia, which is what they did with my case for failure to appear for jury duty. They also dismissed it at cost to the defendants. So violations all across the board, just like I knew it would happen. Even the clerks are negligent in their duty. Of course, this is all my opinion. This is not legal advice. So keep in touch. I'll be doing the next update here soon. Thank you much, and know that I love you. But I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That part's on you.